I had a tour around the campus today, and you wouldn't believe how much has changed since 1978. It's quite extraordinary what's happened here, and it's a magnificent facility. I thought, the heading international deal making, I'm not quite sure what to make of it. So I'm going to tell you a little bit of how I got to where I am, and some of the transactions which were sort of fun along the way. There's a sort of a health warning that comes with it, and it's particularly as it's being recorded, this presentation. I'm going to be slightly careful of some of the bits and pieces I say, because I don't want them to appear on the website and then some somewhat angry clients coming back to me later. But the other health warning, I think, is that it's very much the international practice is very much what you make of it. I didn't plan any of this, and I've got no idea where the rest of my career will go. I certainly didn't expect to spend 7.5 years of my life in Indonesia with White & Case. I actually thought I was going to Hong Kong, but we'll come to that in a moment. At present, I spend a lot of time on what is called project financing, not something that's probably covered in law school syllabuses at present. And I thought if you don't mind, I might towards the end just talk a little bit about it, because it is essentially what I spend a lot of time on, what an awful lot of people around the world spend their time on. And as we'll discuss, it's essentially a means by which you can raise fairly large sums of money financing these massive industrial projects off balance sheet, and that is the key issue. I hope that, other than that, I'll talk about some of the fun things, some of the crazy things that you probably won't believe, and try and talk a little bit about the skills that certainly I've had to use. I also run our graduate recruiting program in the UK, and I thought I'd talk a little bit about the differences between the UK and the profession in the States over here. I actually started my legal qualifications in the States, qualifying in Washington, D.C., and then not realizing, or not waiting 5 years, so then I had to take the bar in New York as well. But this all sort of started, I was, as somebody phrased it, a Navy brat. My father was in the Navy. I lived 2 years here, 2 years there, and I guess I got the travel bug when I was relatively young. I got into law through the Jessup Moot Court competition, international law, through the Jessup Moot Court competition, and ended up coming over here from the United Kingdom to a couple of the finals, unfortunately losing in one of them to the University of West Virginia. But enough said of that. I did the L.L.M. here. I had persuaded somebody to fund me for 2 years in a scholarship. It was a very generous scholarship. It was set up by one Stephen Hartness, who was an industrial steel magnate in the early 20th century, and he established these scholarships to do the reverse of the roads. And it paid for me to come here for 2 years. It then gave me a car and an allowance to travel for 3 months, and said I had to go to 5 out of 6 regions of the United States. And so with my brother and I, we left here in May 1 year, and 3 months later, and some 19,000 miles, we had driven all the way around the States and gone to Acapulco. And so it was a fantastic time going around the States and trying to understand this country. When I finished the scholarship, I worked out at that time that actually it would take me 6 or 8 weeks to qualify in the United States, while it would take me another year or so if I went back to the United Kingdom. So I did the Barbary course. I went to Washington, worked for a firm called Untitled Chapter for a year. They had an international foreign lawyers program. They didn't realize I wasn't qualified in England, but they gave me a job for a year, and I qualified in Washington, D.C. Unfortunately, there was a moral commitment I had, which was that I should leave the United States. And in those times, Arnold & Porter only had one office outside the East Coast, which was in Colorado. And as a result, I looked around to go somewhere else, thinking that I'd end up going back to London. And I ended up, White & Case offering me a job, and I moved to New York. And interestingly enough, I had spent my time when I was at UVA focusing on the law of the sea. It was a particular sort of hobby horse. It was one of the things I'd done in the Jessup Moot Court competition. And amazingly, almost the first thing I did at White & Case was to analyze the rights of a U.S. company engaged in fishing off the Kiribati Islands, which I didn't even know existed, but were the former Gilbert and Ellice Islands, and there were issues relating to the law of the sea and whether the country was entitled to enforce a 200-mile exclusive zone. And that was sort of a bit of what seemed to happen at White & Case, certainly when I left the United States. I had originally planned, I thought, to go to England, and I kept on badgering the relevant partners, and they said, well, no, we haven't got any vacancy in the London office, which was quite small in those days, about 5 lawyers, but we do have vacancy in Hong Kong. So I thought, okay, fine, I'll go to Hong Kong. What they hadn't told me was that the Hong Kong office was a staging ground for servicing our practice in Indonesia. And a year and a half later, having commuted every 2 weeks to Indonesia, I basically said enough was enough, so they suggested that I should move to Indonesia. I indicated to them it was like having an office in San Diego and staffing it from New York on a revolving, rotating basis, and it really wasn't on. I mean, it was like 4 or 5 hours flight from Hong Kong to Jakarta. But the practice that we did in Indonesia, which was certainly the genesis of my international practice, was based upon a relationship that our chairman at the time had with a group of investment banks. They were called the Troika, and it was Lazard Brothers, in those days before it merged with American Express and then I guess demerged later. Warburgs, who were obviously at that time an investment bank in London, now part of UBS, Lehman Brothers, Warburgs, and Lazard Frères, who were in Paris. And they went and advised developing countries on their debt situation and debt problems. And one of their partners knew Jim Herlock, who was our chairman at the time, and as a result, we got involved in an awful lot of work in sorting out the debt problems and restructuring the debt in various developing countries, from Zaire to Turkey to Indonesia and other Latin American countries as well. So we had this presence in Indonesia, and we had a group of lawyers who existed in a rat-infested office. It was sort of a bullpen. It had the asbestos-type ceilings with dark yellow stains on it, and whenever our managing partner came down, we'd get the rat catcher out. And in Indonesia, the rat catcher was a piece of wood with glue on it, and they'd put it out in the night before, and you'd walk in the next morning and see what you'd caught. And so we always made sure that we had a good supply of rats whenever he came down, so we could argue that we were in a jurisdiction which we needed various benefits to compensate for the rats and everything else. But it was a fascinating practice. It was quite extraordinary what came in the door. And I thought what I would do is talk a little bit about some of the things that came in the door. You will appreciate that obviously I'm not an Indonesian lawyer. I eventually ended up learning Indonesian, probably because in some respects it's a fairly easy language to learn. It doesn't have any futures. It doesn't have any past tenses. And if you want to pluralize anything, you just repeat it twice. So as a result, and hopefully with no offense to Bahasa Indonesia, it was even something I could manage. But we were very fortunate as a firm to be located in the central bank. We advised the central bank on its debt issues. We advised the Department of Finance on its debt issues. And we then happened to advise most of the state-owned companies on their investment and development programs, which were substantial in the 70s, 80s, and 90s. Lou referred to LNG. As of now, Indonesia is still the largest exporter of LNG. And certainly from the perspective of my own career, the experience I got in that industry in the 80s has held me in good stead in the 90s and into the last few years, where Qatar, which is the second largest exporter and shortly will become the largest exporter of LNG, has used our services in a number of its projects. But coming back to Indonesia, one of the first things that came was a call to go to the state telephone company called Perumtel. And so I went over there one day, having absolutely no idea what I was going to be asked about. And they explained that they had a satellite that was being launched by NASA. And the way you launch satellites in those days was that they went onto the shuttle and they were released from the arm of the shuttle, and then they had a booster rocket that would take them up to a geosynchronous orbit of 22,000 miles or whatever it was. And there was a problem. Morton Thiokol, which built the booster engines, for some reason, they and for the Paramtel satellite, Palapa B2, had flooded the engine with too much hydrogen or whatever it was, and as a result, there was no flame, explosion, and rocket to take it to the proper orbit. And the problem was that NASA had said that they would like to recapture the satellite and bring it down. And the question then was, from a legal point of view, well, all right, what are the rights? What are the provisions of the insurance policy? And frankly, I'd never read an insurance policy before that day. And it was the most extraordinary insurance policy. And part of the moral of what I'm going to talk about in international deal making, it's read the documents and work out what the risks are and what your client has accepted and what he's liable for. This was an insurance policy which said that if the satellite did not get to this geosynchronous orbit, 22,800 miles or whatever, it was deemed a constructive total loss, which meant that under the terms of the insurance policy, the insurers had to pay out because it was regarded as a loss, and that was the end of it. Of course, these policies were written before anyone thought of the shuttle. Anyone thought that maybe if you're at 120 miles or 200 miles, maybe you could actually bring the satellite back. So from the perspective of a lawyer, that was sort of nice to know. We were entitled to be paid our $80 million, thank you very much, and walk away. Unfortunately, the policy went on to say, and normally if you have a constructive total loss and your car's written off, then the insurer takes the car and does whatever it wants to do with the car. Well, this policy said that even though there was a constructive total loss, and even though they paid out, Paramtel kept ownership of the satellite. So I thought, okay, well, this is even better. We've got our $85 million that we're entitled to, and we still own the thing. The third aspect of insurance with satellites, and again, I didn't know anything about this until I walked in and started reading it, was that there was a public liability policy which said if anything happens within the first 3 years, you're insured from the damage that might happen because the satellite falls back to Earth and kills somebody, lands on a cruise ship or whatever. So when you sit and you analyze those three factors, you work out that sometime within the next 3 years, you've either got to get rid of this thing, transfer it to somebody else, or bring it down to Earth, let it burn up on re-entry, and then at least you've still got an insurance policy. And of course, the insurers were sitting there thinking, oh gosh, NASA wants to recover this satellite. We can bring it down, we can reservice it, and then we can sell it on to somebody else. And so we were then engaged for 6 months in a negotiation as to when was the window when there was a shuttle available to bring it down, when could we fire the engines to bring it down, and finally, from our perspective, when were we going to transfer title over? Because obviously we did not want a fully fueled satellite sitting on the shuttle, coming back into re-entry, coming back to landing, and if something was to go wrong, who was going to be liable? Because the fuel for a satellite is normally 10 to 12 years, and so this would have been a fully laden, fueled satellite. So we had these fascinating negotiations, which took place in Washington, and I flew from Jakarta to Washington a couple of times. The first time we walked in, the lawyers on the other side had done all these documents about transferring title and paying money and so on. There were piles of documents. And our client, who was the Director General for Telecommunications, said, we're not reading any of those. We just want our money. And so we negotiated for the next 3 months as to how to bring the satellite down, how to transfer title. And eventually we agreed that we would give the instructions to bring the satellite was at 200 miles, and it had to get down to about 120 for the shuttle to be able to capture it. We would give the instructions so long as, first of all, we got an indemnity from the insurers so that we weren't liable as we brought it down. And then secondly, the transfer of title issue. And then at that point in time, we transferred title, we got the money. And so we were all fairly pleased with ourselves that having done this and having brought it down and having got the payment out. But at the end of the day, the legal skills were basically contract. That's all it was. It was reading the insurance policy, working out the risks, and then trying to see how you could get to what your client wanted, and at the same time deal with a set of circumstances where there was no precedent, nobody had ever done this before. And I guess at that time I was sort of a third or fourth year associate in the Jakarta office, and every day I'd come back after these meetings or wherever I was traveling, and there would be a partner going through line by line what I'd written, try and check to see what I'd done, and it was a fairly stressful time, but it was absolutely fascinating. The second thing I thought I'd talk about was a restructuring in Saudi Arabia. Again, an issue about risk allocation, reading the documents. Our client had borrowed an awful lot of money and had no ability to pay it back whatsoever. The only advantage our client had was it had no assets outside Saudi Arabia. And trying to enforce assets and security against assets, or enforce in a bankruptcy in Saudi Arabia when there were no bankruptcy laws in those days, meant that we had a set of cards which allowed us at least to negotiate a restructuring. Again, the issue here was trying to work out exactly what the assets were, what the loan agreements said, and many of these loan agreements were literally one-page agreements with somebody's signature on it. And the issue was, did they sign in a personal capacity? Did they sign as chairman of this company? And as you can imagine, with borrowings in the late 70s and early 80s, there was no documentation. And again, it was an issue of going through, trying to analyze what the risks were, what the liabilities were, who had said what. It was okay to our client, don't travel abroad to these jurisdictions because you may have a problem with these because of being, having lawsuits brought against you in a personal capacity. And again, that involved a time when I had been in Jakarta 3.5 years and I was told I had to go back to New York to make partner, because in those days we made partners out of New York. And so I went back to New York thinking I was actually going to work in New York for 2 years. And for those of you who end up in New York, there's a provision in the New York state income tax which says, at least when I was there, which says basically you don't get taxed on your income for those days that you work outside New York, outside the state or city of New York. So what you do is you keep a religious record of how many days you're outside New York, how many days you're in New York. And I calculated every time I filed my tax return that 58% of my time was not spent in New York. And it wasn't spent in Washington or Louisiana. It was spent in Jeddah, London, and Pakistan. And so this was commuting back and forth, trying to work our way through this restructuring. There was a California law firm on the other side. And again, it was a process of just analyzing what is our assets and where we were going. I mentioned Pakistan because at the same time, our client in Saudi Arabia had a cement plant in Pakistan. And he'd entered into a contract with a Romanian company, and this is pre the sort of dissolution of the Soviet Empire. And the Romanian company had provided financing for the cement plant. Essentially, it provided 50% financing and 50% was paid in cash. It's called, in the vernacular, a supplier's credit. The credit comes from the supplier, he gets paid back, and he sells the goods and makes the profit, essentially, on the price of the plant. And it's a fairly common technique that's used in funding. It's certainly a technique that's used in project financing. The only problem was that some of the documentation was slightly wrong from the Romanians' perspective. In these project financings, you normally have a repayment period, and it keys off either an event happening, completion of the project, or a fixed date. Unfortunately for our lender and builder of our cement plant, they'd forgotten to put the date in. So what the contract said was they would get paid back over 10 years after completion of the project. Well, the project was terminated once and reinstated, and when it was reinstated, the contract underlying it was governed by English law. And what the contractor at that time, the Romanian entity, had said at that time was that it would be liable for all direct damages but not consequential damages in connection with the delay and so on and so forth of the project. Unfortunately, they hadn't consulted an English lawyer when they'd agreed to that. And under English law, loss of profit is a direct damage, not a consequential damage. So as a result, what had happened was that they had signed up to a liability for all the loss of profits and delay of completing this plant. They then proceeded to continue to build this plant, and it was a pretty sorry state of affairs. They didn't have enough foreign currency to pay their workers. Their workers were constantly on strike in Pakistan. And eventually what happened was we decided to terminate the contract. And we terminated before completion, which then left another problem because under the contract, as the repayment period had not started for the 20 installments, every 6 months over 10 years, the claim had to be made under, and frankly my US law has disappeared, but it's certainly under English law it was going to be a quantum meruit basis, i.e. what was the value of the services and the goods delivered. If that wasn't bad enough, the contractor decided to go and obtain relief, injunctive relief in the Pakistani courts to stop a termination. Now, under most arbitration statutes, there's a provision which says that if you go and seek interim relief, you don't waive your rights to seek arbitration. But on the other hand, if you seek permanent relief, you've effectively opted to proceed in the courts and not to proceed by way of arbitration. Well, our beloved opponent decided to seek permanent relief. And about 6 months later, he woke up to the fact that he'd gone and sought permanent relief, because as soon as he went for permanent relief, we counterclaimed for permanent relief, because we thought, well, we're going to get them really into a quagmire of permanent relief and therefore force a waiver of their arbitration rights. And in fact, when they woke up to the fact that they had an arbitration clause, they then proceeded to file a notice of arbitration, ICC arbitration. And not only did they join the counterparty to the contract, but they decided to join the parent of the counterparty, which happened to be this Saudi entity that was in bankruptcy, or at least had severe problems. And just for good measure, they also joined the 66% shareholder in the parent company. As you all know, an arbitration agreement only works against those parties who've consented to it. The ICC, in their wisdom, decided to let the arbitration go ahead. And at which point, I switched from being a corporate finance lawyer to being an arbitrator with my colleagues in Paris and in the States. And we decided that the only way to deal with this was to sue the ICC. And we decided to go into the courts to sue the ICC on the basis that they'd exceeded their jurisdiction. That got the French government a little upset. So they then proceeded to enter the proceedings in order to try and defend the ICC, because the ICC was based in Paris. And, of course, what we were after at the end of the day was the situation with respect to the parent and the principal shareholder of the parent, who'd been joined to this arbitration without their consent. This flowed on through time, and eventually the ICC changed their mind. They threw out the arbitration against the parent and the principal shareholder, and then after the arbitration commenced, obviously the first issue before the arbitration panel was whether arbitration had been waived by nature of the proceedings in Pakistan. And eventually, on a 2-1 vote, the arbitrators decided it had been. They threw out the arbitration, and as far as I know, the case is still proceeding in Pakistan at present, some 14, 15, 16, 17 years after this initial event occurred. And of course, in the meantime, the plant has been producing cement, and there's been a fairly active building program going on in that part of the world. Again, it's an issue of the whole problems for the contractor in this business came about, A, because of the contract they signed, B, because of the agreement they entered into under English law without understanding what it was, and thirdly, because they didn't understand how financings are normally done and how you separate the construction contract from the repayment of the debt. And they hadn't done that. Again, it was an interesting experience. It involved me going to Pakistan 3 days before the end of a year. I think it was in 1986. And when I arrived in Pakistan, General Zaire was in control. Alcohol wasn't exactly the spirit of the occasion. I remember on New Year's Eve calling up the hotel room service, asking if they had any champagne. I was told no. So I said, how about white wine? No. They said they had some local beer, but in order to give me local beer, they needed a copy of my passport and a certificate to say that I wasn't a Muslim. So I spent New Year's Eve in between these discussions drinking local beer with my certificate that I wasn't a Muslim. That was sort of the last fun one while I was an associate. Then I was made up to partner with an offer you couldn't refuse, namely to go back to Indonesia for 3 more years, which I did. It wasn't quite as much fun as the first time. And 3 years later, I moved to Germany. Again, I couldn't quite get the firm to persuade me to go to London, so they moved me to Germany. We opened an office in Germany. We closed an office in Germany, and eventually I got to London. And when I got into London, I was the 11th lawyer in the London office. And we were asked shortly after if we could advise a group of banks based in Paris in connection with the first LNG project that Qatar was going to undertake, called Garagass 1. It was a deal that took 2 years. the sponsors came up with different types of structures, none of which really worked. But we eventually got that transaction done. It was incredibly complicated financing at a time when nobody had done any project financings in Qatar before. There was no law of security. You had these very complicated fiduciary transfer arrangements whereby, in order to get security over the plant, the project company transferred the assets to an offshore company in the Cayman Islands, which then owned the assets, and then you could take security over the company that owned the assets, and then you basically leased the assets. Now, that was one of those wonderful cases where lawyers worked hard and diligently to put this structure in place. Two English firms did it. I doubt if it could have been enforced. I certainly know the Qataris wouldn't have allowed the assets to be seized, transferred, broken up, or anything else. So it was one of those cases which was an intellectual exercise and no doubt kept lawyers very happy, probably earned quite a lot of fees, but showed that at the end of the day there was a question of reality as to how you do these projects. But I'll come back to Qatar in a moment when I talk a little bit more about project financing. While we were building a practice in London, there was a project that came along which I spent 5 years on called the Cross Israel Highway Project. Now, Cross Israel Highway is it's not quite the right term because it's actually a road that goes north-south rather than east-west. And it was a road that was envisaged at the time as being part of a massive road program that would go from Turkey to Egypt. And obviously events over the last 10 years have made that somewhat difficult to realize, at least at present. But we were retained by the Israeli government and a state company that was established to advise them on a concession for establishing the road, which would then be bid out to various different bidders in a competition, and which would then lead to this road being financed. So for about 5 years, we worked with the government and the various ministries, particularly the Ministry of Finance, putting this concession together. And literally, we started in November 1995 with a blank piece of paper, and we built up the concession. We worked with the government to do it. We went through a couple of changes of government, which actually caused quite a lot of disagreement as to whether the road was going to proceed or not. And so it was Rabin was the prime minister, then he was assassinated, then Bibi Netanyahu came along. His minister of infrastructure was Ariel Sharon, so Sharon got involved and took it on as this was going to be his project. And as we did this, I thought the biggest risk was going to be who was going to take risk of building and investing money in Israel. And the problem, of course, is that I was looking at it from London and thinking about the risk profile and who was going to do that. And, of course, the reality was there were huge amounts of capital in Israel. The Israeli banks and pension funds and so on had access to enormous amounts of money. And, of course, to them, Israeli risk wasn't risk because they were incorporated in Israel, their assets were in Israel. So, in fact, the financing went through reasonably smoothly. And the 5-year plan was really just to try and deal with all the problems coming out of doing a project in Israel. There's an antiquities law which says that if you come and you find a site and there are ancient remains in the site, you then have to go through a process of establishing whose remains they are, who are the people who were likely to have, whose remains those were, and whose remains they were made a difference as to what happened under the antiquities law. So you had to deal with risks like what happens if you come to these antiquities, how do you deal with that? The road runs, if you ever go to Israel, the road runs right along the Green Line. And for a period of time, there was a lot of shooting for the workers as they were building the road. There are now these massive great walls that you will have read about as being constructed along the Green Line between Israel and the West Bank. And literally they abut right up to the road in a large number of places. Again, you had to deal with all these issues in the context of a risk allocation. How do you protect the contractor? How do you deal with situations where you can't work because of civil disobedience, you can't work because of the antiquities issue? All in all, an extraordinary period of time, particularly with what was going on in the Middle East. I thought what I would try and do, and I've got a couple of slides here which basically just discuss a little bit about project financing. If I bore you, shout me down or something, because I could go on for hours, but I won't. But try and give you an idea of the conceptual framework, and then take a project, which I can do is the Getagas 2 project, which is this project we we completed a couple of years ago, raised some $7.5 billion of debt to put in place a supply of gas, which when it is complete next year and the year after, will enable the United Kingdom to have 20% of its gas coming from Qatar. An extraordinary project, but one which you'll see, or hopefully you'll see, while it's very complicated when you first look at it, if you break it down, it's actually a manageable thing to deal with. No, that doesn't work. Let's go this way. All right. This is your basic project financing. And as I said, I will be very brief on this. Essentially, the idea of a project financing is that you borrow money and it's off balance sheet. So it doesn't sit on the balance sheet of a company. They can separate themselves from their liabilities and the assets of that. So you have a project company which is established. You have a contractor who's going to build something, making widgets, making iron, steel, whatever you want. You've got somebody who's going to buy it, the off-taker. You've got somebody who's going to supply the iron ore or whatever the raw material is, and then you've got somebody who is running it, the operator. And then you've got the lenders. Now, the key issue in all of this is that nobody's providing any guarantees around here that the debt's going to get paid back. So from the perspective of the lenders, every single one of the people who've got an obligation, whether it's an operator, a contractor, or an off-taker, have got to perform their obligations. Because once they've delivered the $7 billion in the case of Gatagaz 2 or whatever it is, you don't have recourse to anybody except to the extent they don't perform. If the price goes wrong of the widgets or whatever else, you take the risk as a lender. So it is a very document-intensive exercise, and once again comes back to the joys of contract and your direct damages and your limitations of liabilities. This slide just shows what the lenders try to do, which is they try and get an assignment of all the project company's rights, whether it's the off-taker, whether it's the contractor, whether it's the feedstock supplier, the operator. They all agree with the lenders two things. One, will do what we said we're going to do, and secondly, if there's a default and you remove the project company, we agree to continue performing for the benefit of the lenders, so long as the lenders take over or put somebody else in place. So if you take that structure, which it actually doesn't matter whether it's a toll road, whether it's an LNG project, whether it's a telecommunications company doing a new mobile phone system, essentially what you're looking for is something that's generating revenue and then getting your hands on it. So you come to the Gatagaz 2 and sort of going to build this up so you can understand how all these pieces actually can come together. Gatagaz 2 involved the government of Qatar entering into what was called a development and fiscal agreement, whereby they agreed with ExxonMobil and Qatar Petroleum that they would allow those two companies to form an SPV, Gatagaz 2, to develop gas from the North Field. Qatar has the largest, what they call non-associated gas field in the world. Non-associated means it's not connected to crude oil. It is there just as gas, and is located in the Gulf between Qatar and Iran. And so the government entered into this agreement with these two companies, Qatar Petroleum and ExxonMobil, and allowed them to exploit a certain amount of gas for a period of time. Gatagaz 2 then enters into a contract to build. Essentially what they were doing was building a number of offshore platforms to bring the gas up, pipelines to bring it ashore, and then massive, great liquefaction plants to convert the gas into a liquid. The gas is very much, when you freeze it and compress it, it becomes a liquid and then it's transferable. Gatagaz 2 then enters into a series of agreements with an operator, with Qatar Petroleum to produce the land and to use the port, and technical services. Then Gatagaz 2 enters into agreements for the sale of the product that we're talking about. Here it's condensate. When you take the gas out, the gas includes condensate, which is a very rich crude oil. So instead of the gas being with the crude oil is actually with the gas. And so what they do is they enter into agreements whereby somebody agrees to take the condensate, because if you didn't take the condensate, you couldn't take the gas out, because eventually if you didn't do something with the gas, you'd just be ending up with all this condensate slopping around, and you'd have to stop operating. They then entered into an LNG SPA sale and purchase agreement with Southhook Gas, which was a company formed by Qatar Petroleum and Exxon Mobil. That was a company that was formed in order to bring gas into bring LNG into the United Kingdom. And they then went off and arranged for the construction of LNG ships. These are massive vessels which can take at refrigerated temperature the liquid gas, from Qatar in the Middle East to the United Kingdom through the Suez Canal. And what you end up doing, each of these vessels costs $200-300 million. So if you've got 8 of these vessels, you've got $2.5 billion just sitting in the cost of the tankers. And what you do is you go out and you finance that. You get somebody to lend you the money to build them on the basis that Gathergas 2 will pay a charter party, will pay in effect lease to use the vessels. Southhook ends up buying a load of LNG. So what does it do with it? Well, it brings it ashore at Milford Haven, which is an old Esso refinery in Wales, and puts it through a terminal which essentially gradually warms the gas up. It takes the liquid form and warms it up. And so what they do is Southhook Gas Company enters into an agreement with Southhook Terminal, again owned by Qatar Petroleum and Exxon Mobil, whereby Southhook Terminal says, we'll build a regasification plant and we will process in return for a fee your LNG. It's called the tolling agreement. The key issue there is that title to the LNG never passes to Southhook Terminal. Southhook Gas Company always owns the LNG and the gas as it becomes gas, so that a creditor of Southhook Terminal can never get hold of the gas. All it has is a contract with Southhook Gas, whereby Southhook Gas says, we will pay you X amount to process the LNG into gas. Southhook Terminal goes off and borrows money based upon the credit of Southhook Gas, i.e. what the lenders say is, okay, we'll lend you the money so long as we've got a terminal capacity agreement which ensures that we've got a cash flow coming back. Again, so you've got a project financing at Gathergas 2 for the liquefaction plant in Qatar. You've got a project financing at Southhook Terminal in order to ensure that you raise the money. And you then have Southhook Gas sending this on to EMGME, which is ExxonMobil Gas Marketing Europe, who buys the gas. And then there is a guarantee of ExxonMobil's marketing entity by Esso UK, which is the principal ExxonMobil entity. So that is the structure that was financed in the Gathergas 2 financing. And it was something that took us 7 months to put the structure together, just negotiating with our clients, ExxonMobil and Qatar Petroleum. And then it took us a year from beginning to end to raise the money. There was, as I said, there was at Gathergas 2, there was a financing of over $6 billion, and then at Southhook, there was another financing. And the financing structure looks something like this, at least for Gathergas 2, which is the Qatari liquefaction plant. There was a commercial bank facility of just over $3 billion. There were two ECA facilities, the SACE, which is the Italian Export Credit Agency, and US Exim Bank, the Export-Import Bank of the United States. These are entities which you may or may not have come across, but they're essentially established by their governments in order to encourage the sale of goods and services from their country. Finally, there was an Islamic facility. As a result of developments in the Middle East over the last 3-4 years, a huge amount of the petrodollars that used to flow into the United States are no longer flowing into the United States. They're still in dollars, but they're actually being kept offshore, predominantly in the Middle East, by a large number of Middle Eastern governments and investors who raise some issue as to whether funds would necessarily be safe if they were in the United States at present. So there's huge amounts of money sitting in the Middle East to be invested. What happened here was that Gathergas 2 raised the money from the commercial, the Islamic, and the ECAs, And ExxonMobil, as part of the deal they had with the Qataris, agreed to put in a matching amount equal pro rata to their share of the project. So we then had a shareholder loan facility as well. And for those of you who are interested in finance and sort of corporate finance, if you're a bank, the last thing you want to see is a shareholder lending at the same priority as you, because essentially you're then worried as to whether the shareholder is going to disrupt any restructuring, any activity being taken, and so on. But these facilities were at the same level, but with certain restrictions as to voting rights and so on, so that essentially the commercial facilities, whether Islamic or commercial banks, had the decision-making. Islamic facilities are sort of interesting because the way an Islamic financing works is you have to have an asset. Essentially, what you need to do is have an asset which they then finance, they buy the asset, and then they lease it to the entity concerned, in this case, Gatagaz 2. So essentially there was a sale and leaseback. Gatagaz 2 had these facilities, certain equipment built, transferred it over to the Islamic lenders, who then leased it back to Gatagaz 2. And there was no interest as such, because what was being paid was a lease payment, not an interest payment. Of course, the reality is that the lease payment corresponds to, in effect, a de facto interest type payment, but it's not classified as an interest payment and therefore is Sharia compliant. It raises a problem if you're doing a financing, because that means that this entity owns assets. It owns assets that otherwise would be owned by here. So these other lenders will get worried as to whether the Islamic lenders can take their assets and sell them off separately from the rest of the lenders. So essentially you get involved in a whole series of discussions, intercreditor discussions. And then the final two pieces of this slide essentially show what happens with a security trustee who acts on behalf of the lenders. There were guarantees from the sponsors for completion, not to take the risk of whether the LNG, whether the gas is going to be sufficient to pay back the debt, but there were guarantees that the project would be completed. So you'd get construction, you'd get acceptance of the liquefaction plant, you would get acceptance of the facility in the United Kingdom. And then these direct agreements are similar to the direct agreements you showed before, whereby the lenders and the security trustee enters into all these agreements. But essentially what you've done by putting all this together and by breaking this into manageable pieces is to arrange for a very large financing, which if you looked at it like this may look fairly complicated, but when you break it down into individual components is actually manageable and you can do. And since we did that project and finished it in 2004, we then did Gatagaz 3, with ConocoPhillips, which is sales of LNG to the United States, and we're in the process of finishing Gatagaz 4, which is sales to Shell, some of which will come to the United States. Others will go to Europe. But the original model, which took us 19 months to do, we've now reduced it to about a 10-month period from beginning to end in order to put the financing together. These kinds of deals, from my perspective, I doubt if I ever see anything like this again, because it's changing the model of how you do these projects. We built in huge flexibility into Gatagaz 2 as to the fact that it could expand, that it could borrow more money, all the things that otherwise lenders try to restrict. We tried to build into the arrangements that supported this financing. But again, that essentially comes down to, from the point of view of financing something like that, and from the point of view of doing the kinds of transactions that I do, it comes down to analyzing what all the risks are in each of these agreements that you have here, whether it's a services agreement, a construction contract, analyzing the risks and then trying to work out from the borrower side, how do you make them sellable to the lenders without restricting your ability to operate the plant. So, that's one aspect of international deal making. Some of my colleagues and partners will spend a lot of time dealing with securities transactions. We have offices in places like Moscow, Almaty, Eastern Europe, where you've seen a lot of access to the securities markets, and predominantly the United States, because it's the largest source of capital in the world. so that you will see that they will work closely with the securities partners that we have in London and New York. And similarly, from the perspective of things like arbitration litigation, you will see these cross-border matters, particularly arbitration, and of course in structuring these kinds of transactions, you're desperately trying to work out which jurisdiction you can rely on. Interestingly enough, the key to this whole financing structure was over here. This was an entity which was owned by ExxonMobil and Qatar Petroleum, but at the same time there was flexibility as to what this entity could do in the future. So from the point of view of the lender, this was absolutely crucial. This is your revenue stream. Here and to here is your revenue stream, and if anything happens to this entity, you run the risk of losing the flow of funds back to Gatagaz 2 to pay off the debt. And here there is a crucial difference between the bankruptcy law in the United States and the bankruptcy law in England and Wales. In the United States, as I understand it, if you go into Chapter 11, you basically can't terminate contracts. You have to continue to perform contracts, and then you go through a process of trying to work out which of those contracts you want to maintain, which are the ones you want to set aside. In the United Kingdom, there is no restriction on the counterparties and no obligation for them to continue to perform if their counterparty is bankrupt. So essentially what that meant was that if anything happened to this entity, under English bankruptcy laws and principles, we could arrange for the termination of all these entities of their obligations, and by Gatagaz 2, and we then could put a substitute entity in and leave the creditors of Southhook to go and do whatever they're going to do. And so what we did in order to get over this bankruptcy risk with the lenders was enter into an agreement all the way around here that if this entity ever became insolvent and was unable to perform it, that all these entities would terminate their arrangements, and the principals, Qatar Petroleum and ExxonMobil, would establish another entity through which they would sell the LNG and then the SPA on to EMGME. So an interesting issue where you see how two different laws, two different jurisdictions and principles of law allow you to structure your way around it, something that otherwise you would not be able to do. I thought just briefly I would circle back to the differences between the UK and the profession over here, and really just a little bit so that when you're qualified and you're dealing with English lawyers, you understand where they're coming from, because often there seems to be there's some disconnect in culture at times. And I do it partly from the perspective of being qualified here and in the United Kingdom, and being responsible for the graduate recruitment we have in the United Kingdom. English law degree is an undergraduate degree. It also happens to be paid for by the state. So that as a result, you end up with 21, 22-year-olds who are qualified or who've done their law degree in the United Kingdom. However, they then have to do a postgraduate degree for 1 year, and then they have to do a training contract for 2 more years. And it's only at the end of their training contract that they become qualified in the United Kingdom. Now, obviously, you guys do the undergraduate degree, the postgraduate degree, the bar review, and end up getting qualified after 7 years or whatever. But you will often deal with people in England, and if you go to the firms that are involved in international transactions, I'm sure you will. And it's probably useful to bear in mind that they've had 6 years of practical work and as well as legal qualifications before they get qualified. The second thing, and I was discussing this with Dean Hobson beforehand, the ability for American lawyers to get qualified in the United Kingdom is relatively easy. A few years ago, there was a European Union directive which was basically encouraging the legal professions to open up their markets to lawyers from other jurisdictions within the European Union. And it had a tremendous amount of resistance in the United Kingdom because, of course, the United Kingdom, together with Ireland, are probably the only 2 common law jurisdictions in the European Union. Everyone else has the code imposed upon them by Napoleon. And as a result of that, what happened was the Law Society in England said, okay, fine, if we're going to do that, then we're also going to allow a liberal regime with respect to people from common law jurisdictions. And there'd always been a liberal regime with respect to Canada and Australia because they were Commonwealth countries. what happened was there is now something called the Qualified Lawyers Transfer Test in the United Kingdom, which basically says that if you've qualified for 2 years in a common law jurisdiction, whether it's Washington, New York, Pennsylvania, wherever, you can then take this exam, which essentially consists of 4 subjects. And if you take that exam and pass it, you're then qualified as a solicitor in England and Wales. So it's something that you might want to bear in mind going forward. The reality is, if you look from my perspective at what's happened to the legal profession, the English firms very successfully blackened the name of U.S. jurisdictions on the basis of triple damages, huge legal fees, and the like. And what has happened in the last 15, 20 years, at least from where I can see it, is that while New York law is probably the law governing most commercial transactions in the Americas, North and South Americas, and certainly those international transactions which involve entities like US Exim Bank. If you look to Europe and to Asia, the governing law in most cases is English law. Interesting enough, this transaction was done under New York law. And indeed, Gatagaz 3 was done under New York law, Gatagaz 4 was done under New York law. We're doing an aluminum project in Qatar at present. That'll be done under New York law too. But that's the exception to the rule. So, I would say, as you look to your careers, if you're going to get involved in this kind of thing, you need to think about seeing whether there's a benefit of using what, in effect, the Law Society in England and Wales has allowed you to do, which is to get qualified. I mean, I remember I personally qualified here before I qualified in England. I was told by my managing partner that, don't bother, it's not worth the effort of getting qualified in England back in the early 90s. I ignored that advice, probably the only bit of advice he gave me that I did ignore. And it is quite clear that if you're going to be involved in international commercial transactions, certainly outside of North and South America, you will come more and more across English law, and it is something now which is relatively easy to deal with if you want to. So I sort of pass that on by way of reference. Anyway, I think I've talked enough. I don't know if there are any questions. I'm sure there are plenty of things I should have covered that I didn't cover. But if there are any questions, I'd be delighted either now or afterwards to answer them.